Hi, I'm Anna Denton-Jones of Refreshing Law. And this is the third in a series of sessions dealing with the uh, concept of disability under the Equality Act. Now, in the first session, we looked at what actually is a disability and some of the legal rights that have attached to that. And in this session, I want to focus on one in particular, and that's the duty upon an employer to make reasonable adjustments to accommodate the needs of the disabled worker. A few years ago, in a famous case of Archibald and Fife on this topic that went all the way to the House of Lords, Baroness Hale pointed out that typically, in terms of equalities, we are focusing on not treating anybody of a particular characteristic less favourably. But this special obligation to make reasonable adjustments necessarily entails an element of more favourable treatment. So if you think about the classic scenario of a car park, the disabled spaces typically will be those closest to the building in order to enable people to access the building easily, and everybody else has to perhaps walk a little further. Nobody would take issue with that, but technically the people with the disabled spaces are being treated more favourably perhaps than everybody else. So that's the first thing to get your head round in terms of reasonable adjustments. It isn't about treating people the same, it is about giving the disabled person a bit of a leg up in a situation, and we'll come back to that in a second. The critical ingredient, if you like, to trigger the duty to make a reasonable adjustment is knowledge. You can't be expected to make reasonable adjustments as an employer if you don't know that there is a disability. So knowledge can come to you in a number of different ways. Of course, it might be the employee telling you that they have a particular condition that would qualify as a disability, but it can also come from your observation of certain things. It might be a medical report that you've received, for example, from an occupational health service, that gives you information from which you should reasonably know that the disability is there. Now, this can be slightly challenging for employers because technically, unless we've been all the way to a tribunal to establish whether or not in law something amounts to a disability, then we might not have absolute clarity. So there may be cases where it's safer to actually treat something as a disability, even if we're not sure, because then we'll get things right, rather than perhaps take the risk of not doing something. The second critical ingredient, if you like, in this area is that what we're doing when we make the reasonable adjustment is attempting to remove the substantial disadvantage that the employee is at. So case law has established that it doesn't need to be definite that a particular adjustment that we make is going to remove the disadvantage. It just needs to be a prospect of it working, and sometimes it is trial and error with these things. So what sorts of things count as reasonable adjustments? Well, the legislation points us to three different categories. The first will be changes, physical changes to buildings, so obvious things like ramps, lifts, those sorts of things which there are obligations actually in legislation on landlords and owners of buildings to make buildings accessible to disabled people. The second two aspects will be changing things like work arrangements, policies and practices and procedures in the workplace. So this might be adjustments to somebody's working hours, it might be adjustments to their duties, a whole host of different changes that you might make. Now, there must be a point at which too many changes fundamentally alters the nature of the job to such a degree that it's reasonable for the employer to say, I can't be expected to go that far because it would no longer be the job that I employed the person to do. So think about a customer facing role where somebody is saying that as a result of their disability, they actually find it difficult to undertake that interaction with other people, and they ask if they may just stick to doing administrative duties, paper-based duties, perhaps using the telephone and not having that face-to-face interaction. Actually, that you may say is such a change to the role that as employer, that doesn't work for you. And there has to be that line in every single case. It's just a question of how far you go before you get to that position. Now, in the legislation and the guidance that goes with it, employers are advised to weigh up a number of different factors when they're looking at the whole issue in terms of whether or not it's reasonable to make an adjustment. Now, the likelihood of an adjustment being effective will obviously come into it. The size and the administrative resources of the employer will also come into it. So obviously, the larger you are as an employer, perhaps the more you're expected to do. Cost is always a difficult issue, and it's a difficult issue for two reasons. Firstly, the courts typically do not like anybody saying we can't comply with discrimination legislation because it costs too much. They just don't like that. There's all sorts of case law on it. They usually expect the employer to have more than just costs to justify not doing something as their argument. The second reason why costs is a tricky area is that there are funds available from the government through a scheme known as Access to Work that can be triggered to pay for certain changes that might be needed. So, for example, somebody with a back problem might need a specific kind of chair to enable them to sit at their desk and do their job. It's entirely possible that Access to Work would provide funds for that. And certainly I wouldn't advise anyone to not make an adjustment until they've spoken to Access to Work and have found out to what extent Access to Work are going to be willing to provide funding. So, for example, in a recent case that I'm dealing with, somebody is temporarily unable to undertake driving duties, and Access to Work have provided extra funding for taxis on a temporary basis. So it is worth exploring what funding you can find from Access to Work. The difficulty with reasonable adjustments, of course, is that what is reasonable is going to differ on a case-by-case basis. And for that reason, as an employer, you probably want to explore medical advice, get guidance from occupational health advisors, maybe from the employee's GP, discuss it with the employee themselves before making any decisions. There is no obligation to consult the employee, but nevertheless, it's going to be a useful, good practice tool to have conversations with them to establish what changes can be made. There will, of course, be situations where you decide that actually there aren't any adjustments that can be made, but certainly I think it always helps in defending a challenge, perhaps that you haven't made a reasonable adjustment, if you can show the court or the tribunal that you have taken steps to make reasonable adjustments. So it may be that the employee has asked for 10 different things and you've managed to accommodate 8 or 9 of them. Obviously that's going to put you in a stronger position when it comes to arguing about why you couldn't make that step in relation to the 9th or 10th thing that they're arguing that you should have done. I hope you found that useful. I'm obviously conscious that this session has run on a little bit. It's double the length that I would normally speak for. Thank you for listening. If you've got any queries, please do comment on our page. Thank you very much.